So ito po ay important topics in labor laws and social legislation. So you have chosen important topics that you need to understand to have a complete grasp of labor laws and social legislation. But before that, I would normally tell my students that we lawyers are the most prayerful of all the professionals. Why? In all pleadings we submit, there is always a prayer. Pero ito yung prayer ni Saint Thomas More, ha? Yung patron saint of the lawyers, yung nasa taas, hindi nasa baba. My students know this. Sabi niya, Lord, grant that I may be able in argument, accurate in analysis, strict and study, candid with clients, and honest with adversaries. Yung honesty yan, napakahirap hanapin. Kaya buti pa daw yung mistake, honest. Ba? Buti pa yung tanghali, tapat. Kayo kaya. Okay, so hopefully our internet hindi magloloko. Hindi katulad ng mga jowa nyo. Madalas nagloloko, madalas unstable. Sit with me at my desk and listen with me to my client's plains. Read with me in my library and stand beside me in court so that today I shall not, in order to win a point, lose my soul. So you would like to acknowledge our sponsor this afternoon. Hindi mangyayari itong libreng lecture na ito kung wala ang Rex Bookstore. Andyan po si Miss Jovelyn Villosilio, Rex Bacolod, Iloilo yata, o Bacolod. And then Miss Mela, and then yung kanilang manager. Then of course, we would like to acknowledge Din Terol, and later probably Din Turla of UNOR would join us. So thank you, Rex Bookstore, not for my hair and makeup, but for sponsoring this afternoon's lecture. Ayan, sa akin kasi dalawa lang ho ang publisher sa Pilipinas. It's Rex Bookstore and others. Okay? So, you may also join this or subscribe to this YouTube channel para madagdagan yung mga kaalaman natin. And for free materials, nagbibigay ho tayo ng free materials lalo na pag malapit na yung bar examination. You may join that YouTube, not YouTube but Facebook group. Hanapin nyo lang ho yan. And then try to honestly answer the questions. No? Then, syempre, yung mga lectures natin, kukunin natin dito sa librong ito, published by Rex Bookstore. Then if you want lectures or materials in Constitutional Law 1, Rex Bookstore din yan. Constitutional Law 2, Rex Bookstore din yan. At Public International Law, Rex Bookstore din yan. Loyal tayo sa Rex. Hindi, lahat ng aking law books ay sa Rex. Other books may be published by other publishers, but in the field of law, wala namang exclusivity. Kaya lang mas at home ako sa Rex Bookstore. Not because they are the ones sponsoring this, but because that's the truth. Alam nyo, lawyers should never tell a lie. And lawyers should always tell the truth. Okay, why are we here? Ito ang gusto natin na makasama natin sa groupie itong si Madam. Bakit? Kasi pagkasama nyo sa groupie, ayos na ang buto-buto. You are signing the role of attorney. Hindi po yan ang ating bar confidant. Stop siya doon sa office of the bar confidant. Okay, so according to this lady, Vice President of Apple Company, everyone talks about building a relationship with your customer. I think you should build one with your employees first. As I love to tell my students, the company's products are produced because of good employees. So if you do not have good relationship with your employees, how can you be a good company? How can you attract customers? That's one thing that probably nakalimutan ng ating mga employers paminsan-minsan. And part of taking care of our employees is Republic Act 11058, the Occupational Health and Safety Standards. Na kailangan safe yung ating workplace. And if the employee finds out that there are imminent danger situation in the workplace that may result in illness or injury or even death, he can refuse to report to work without reprisal unless the employer has undertaken efforts to eliminate that danger. Why? Because health is the real wealth and not pieces of gold and silver. Diba? Yan din ang sinasabi ni Buddha, sinundan niya yung sinabi ni Mohandas Gandhi o Mahatma, means great spirit. Health is the greatest gift. Contentment, the greatest wealth. Kaya pagka kontento kayo sa buhay, mayaman kayo. faithfulness, the best relationship. Kaya lang, ang mga relasyon ngayon, sabi ko nga, parang mga Bluetooth device lang. Pagkasama mo, connected, pero pag tumalikod ka, searching for other devices na at nakikinig sa lahat ng Wi-Fi. Mahirap yun. So under the Constitution, you have Article 13, Section 3, that the state shall afford full protection to labor, local and overseas organized and unorganized. By now, dapat alam na ninyo kung ano ang organized labor at an unorganized labor or industry. Okay? Promote full employment, equality of employment opportunities for all, and guarantee the rights of all workers to self-organization. That's a constitutional right. Peaceful concerted activities that includes the right to strike, but in accordance with law. And on that basis, government employees do not have the right to strike because Executive Order 180 pursuant to the Civil Service Law does not allow strikes in government service. In the private sector, meron yan. Mamaya, baka madaanan natin, Article 278, strikes, picketing, and lockout. Kaya pag inaanto kayo ngayon, magpicketing kayo. That is your right under Article 278. So tanong, bakit may labor? Kasi po may police power. Sabi ni Justice Leonen, that case of Provincial Buses Operators Association of the Philippines versus Department of Labor, labor contracts are subject to special laws on wages, working condition, hours of labor, etc. But in other words, labor contracts are subject to the police power of the state. Okay? So police power. Ano ba ang police power? The most comprehensive, least limitable, all-encompassing of all the powers of the state that may regulate rights and liberty for the promotion of the common good. One example of police power in labor standards ay yung Article 128. That the Secretary of Labor or his duly authorized representatives may visit or shall have access to the workplace. See its records, check the records for violation. That is an exercise of police power. Diba? At any time of the day or night, for as long as work is being performed therein. Ngayon, kung wala naman nagtatrabaho dyan, ba't ka pupunta ng hating gabi? Anong gagawin mo? Mag-ghost hunting. Isama mo na si Ed Kaluwag. No? Baka marami kayong mga ramdaman. That's one, police power. Now, number two is social justice. Of course, pag sinabi nating social justice, many of you, if not all, would be thinking of that old case, not even a labor case, Kalalang versus Williams. The social justice, neither communism, nor atomism, nor despotism, nor anarchy, but the humanization of the laws and equalization of social economic forces by the state, so that justice in its rational, objective, secular conception may at least be approximated based on a time-honored principle of salus populi et suprema lex, the welfare of the people is the supreme law. Saan natin matatagpuan ng social justice sa Labor Code? Article 4. Di ba? Mamaya pag-usapan natin. Now, ano ba ang social justice? Sabi ni Justice Sagani Cruz, the policy of social justice is not intended to countenance wrongdoing simply because it is committed by the underprivileged. Hindi porke mahirap ka, lumagbag ka sa batas, hindi ka naparurusahan. That is wrong concept of social justice. Social justice cannot be permitted to be refuge of scoundrels. Masakit na mga pananalita, no? Any more than can equity be an impediment to the punishment of the guilty. Those who invoke social justice may do so only if their hands are clean and motives blameless and not simply because they happen to be poor. Anong issue dito? Illegal dismissal. The labor arbiter found out that the dismissal was legal. Therefore, kung legal ang dismissal, wala kang i-award kahit na ano. But in the essence of social justice, the labor arbiter awarded how much? I think 10,000 pesos financial assistance. Of course, the employer, kung na natin pangalanan yung PLDT, baka mamaya putulan pa tayo ng internet, question ito, raising the legality of the award of financial assistance. Kasi legal yung dismissal eh. That's why the court came up with this ruling through the pen of Justice Isagani Cruz. That you can only invoke social justice if you deserve it, not because you happen to be poor. Yan ang problema sa atin pag mahirap ka, parang ang dami mo ng karapatan, ano? Of course, they are disadvantaged, but that does not give them the liberty to violate our laws. Because the law should apply even to the rich or poor. Di ba? One manifestation of social justice is construction in favor of labor. That is only if there is doubt. If there is no doubt, do not resolve in anyone's favor. Diba? Because while the labor laws are intended to protect the workers, they are not intended to destroy or even oppress the capital. Okay? So you only interpret in favor of labor if there is doubt. If there's no doubt, do not interpret in anyone's favor, but apply the pure and simple meaning of the law. Now, under the Labor Code, particularly Article 295, you have 4 kinds of employees. Regular, project, seasonal, casual. Huwag niyo masyadong paniniwalaan yung mga definition ng Labor Code, ha? Lalo na yung definition ng casual. Pag hindi ka regular, hindi ka seasonal, hindi ka project, casual. So ano ka? Yun nga. Okay? Take note that under Article 295, there are 2 kinds of regular employees. One, those who are engaged to perform activities which are necessary and desirable to the usual business or trade of the employer. A good example are private school teachers. Why? Will you enroll in a school without a maintenance crew, without a janitor? Of course you will. But will you enroll in a school without a teacher? Oh, edi masaya yun, di ba? Madali ka matatapos, walang teacher. Pero, the school cannot operate in the real sense of the word school without a teacher. Therefore, regular yung teacher. Kaya lang, ang probationary period niya ay medyo mahaba under Article 296. Yan ay in relation to the Manual of Regulation for the Private Schools. Okay? So, maganda ito dahil unang araw mo palang regular ka na. But the problem is hindi ka permanent kasi dadaan ka doon sa probationary period as provided by Article 296. Now, in a new case, ito po ay 2022, no? Dito Yangkin versus Lazada Express. Employees who perform activities are necessary and desirable, of course, regular yan. Maybe project din daw or maybe seasonal. At of these 3, project and seasonal employees are generally engaged to perform a task for a specific duration. While casual employees may perform work which are not usually necessary. Under the implementing rules, pag casual, ito po ay incidental lang. So hindi talaga siya necessary or desirable. Now, in the case of Lazada Express, ano ba ang trabaho nito? Ano ba ang nature ng business? Online selling. Platform ito for online selling. So nag-engage siya ng mga delivery riders. Are they regular employees? Now applying the fourfold test according to the court, also known as the economic dependency test. Irregular itong mga ito eh. Why? Activities which are considered usually necessary or desirable in the employer's business generally depends on the industry. There must be a reasonable connection. So ang connection, paano madi-deliver yung mga sinaping mo sa Lazada kung wala siyang delivery rider? That will not complete the transaction. Therefore, necessary and desirable ang serbisyo ng mga delivery riders. Di ba? O, kung naumpisa ng Lazada yan, susunod na dyan yung iba. Kaya ginagawa ng Lazada ngayon, pinapa-outsource na lang yung delivery. Pwede naman yon. Kasi ang papasok doon, yung Article 106, 107, 108, 109 ng Labor Code, contracting, subcontracting, provided yung kanyang contractor ay job contractor at hindi labor-only contractor. Okay? In another case, during the pandemic, itong GMA, kung napapangalanan yung network, ayaw niyang irregular yung kanyang mga cameramen. So, are these cameramen performing activities which are necessary and desirable? Sabi ng GMA network, casual yung mga yan eh. O assuming casual, naka more than 1 year na ito. Ang sabi ng batas, at least 1 year. Whether continuous or broken, they attain regular status. Yan ang problema minsan. Hindi lang naman nag-iisa ang GMA dyan. Even ABS-CBN before. Ayaw din mag-regular ng kanya mga cameraman. I handled one case like that. 20 years na cameraman, hindi siya regular, contractual. Sus, Ginoo. Di ba? Bakit ba kasi ayaw nila mag-regular? Kasi daw, mawawalan sila ng chance na palitan. Ba't mo naman kailangan palitan kung maganda ang trabaho? Kasi nga, pagka ang empleyado ay regular, he enjoys the right to security of tenure, which is both a constitutional and statutory right. Di ba? Under Article 13 of the Constitution, particularly Section 3, nandun yung right to security of tenure. Under Article 294 of your Labor Code, you have the right to security of tenure. What is the right to security of tenure? The right of every employee not to be dismissed without just or authorized cause and in the absence of due process. Okay? Now, in illegal dismissal, take note, walang illegal dismissal dito sa Labor Code. There's no title, illegal dismissal, no article entitled illegal dismissal. No? When is there illegal dismissal? If the dismissal is without cause and without due process, because that is a violation of the right to security of tenure. Now, take note that in illegal dismissal cases, the burden of proof based on Article 292, paragraph B, is on the employer. Kaya alam, may sinasabi din naman ng Korte Suprema that bare allegation not substantiated by facts would not be considered. In illegal dismissal cases, it is also true that the one who alleges must be the one to support his allegations. But according to the Labor Code, the burden of proof is on the employer. However, the fact of dismissal, if disputed, must be duly proven by the complainant. Now, in testing whether there exists employer-employee relationship, do not forget this fourfold test, also known as the economic dependency test, to determine the existence of employer-employee relationship. And according to the Supreme Court, isa-isayin pa ba natin yan? Alam ko, alam na ninyo yan. Selection and engagement, payment of wages. Kaya kahit yung mga jeepney driver, may employer-employee relationship yan with their operator, no? Now, the most important is the control test according to the court. Ano ba yung control test? It is the power of the employer to determine the manner, the method, the means by which an employee would perform the task. Okay? Now, kung ito ang pinaka-importante. Now, applying this, itinanong ng 2017 bar examination, meron bang employer-employee relationship between the driver and the operator of the jeepney? Of course, meron daw. It is not a case of lessor-lessee, but a case of employer-employee. No? Sabi nung operator, teka muna, ibinibigay ko lang sa kanya yung jeep at ibinibigay niya sa akin yung boundary. Well, it doesn't matter how the employee gets paid. What matters is there is control. So it's not lessor-lessee, but employer-employee. So, an employee has been adjudged to be illegally dismissed in violation of his constitutional and statutory right to security of tenure is entitled to reinstatement and backwages. Okay? Yan ang sabi dun sa Equitable Banking versus SIDA. Now, how do we compute, huwag yung kakalimutan ito reinstatement to the former position without loss of seniority rights, because you cannot be reinstated to a position different from the former position you were handling prior to dismissal. Why? Baka ilagay ka sa ibang posisyon, iba na ang criteria for evaluation, problema ka dyan. You have to be reinstated to the former position prior to your dismissal. Okay? Now, the computation of back wages is from the time the employee was not allowed to work up to the time of reinstatement. But sometimes, reinstatement is no longer possible. Kaya may paraan dyan na ibinigay ang Korte Suprema. Now, an award of full back wages according to the Supreme Court is inclusive of all allowances and other benefits or their monetary equivalent from the time of their actual compensation was withheld up to the time of their actual reinstatement. Kasi there are two kinds of reinstatements at the option of the employer. Diba? If you read honestly Article 229, the reinstatement method is at the discretion, not to discretion to reinstate or not, but the discretion as to the manner of reinstatement. Why? The award of reinstatement, as we all know, is not only immediately executory, it is self-executory. You do not need to ask for a writ of execution to execute the award of reinstatement. But under Article 229 of your labor code, the employer is given a leeway as to the manner of reinstatement. He may reinstate the employee physically or to the former position, or reinstate the employee merely in payroll. Aba, masaya yun. Bakit? Aba, hindi ka nagtatrabaho, binabayaran ka kung ikaw yung employee. O, masaya yun. That's why it is left to the option or the discretion of the employer. Now, sometimes it's difficult to reinstate an employee who has been illegally dismissed. That's why separation pay may be paid in lieu of reinstatement. Okay? Kapalit ng reinstatement, bayaran mo yung kanya separation pay. And according to the Supreme Court, since you cannot find this in the labor code, that's 1 month's salary for every year of service. Wala yan sa labor code, but it is provided for by jurisprudence. So what are the grounds that was asked in the 2009 bar exam? What are the grounds that would justify the employer in just paying separation pay in lieu, kapalit, ng reinstatement? One of them is strained relations. Walang kinalaman po yung picture na nakikita nyo sa screen niyo. Under the doctrine of strained relations, the payment of separation pay is considered acceptable alternative to reinstatement when the latter option is no longer viable. Why? On one hand, such payment liberates the employee from what could be a highly oppressive work environment. Yung araw-araw na lang, inihila mo yung paa mo para pumunta sa trabaho. Kasi ayaw mo na, gusto mo nang bumitaw. Pero, wala nang choice. Ayaw mo nang bumalik. So bayaran ka na lang na separation pay. On the other hand, wala rin kinalaman yung picture na ito, it releases the employer from what could be a grossly unpalatable obligation of maintaining its employee or a worker it could no longer trust. Sabi ng Korte Suprema, di ba? So kung ayaw mo nang pagtiwalaan yung tao, bakit mo pa pababalikin sa buhay mo? Pag pinabalik mo, sigurado ka may tiwala ka pa. Di ba? Okay? Now, as to the probationary period, for private school teachers, it's different. Sabi sa Labor Code, Article 296, it is just 6 months. But under the Manual of Regulation for Private Schools, it is 3 school years, as you can see on your screen. Okay? 3 years. 3 consecutive years. School year yan, sabi ng Korte Suprema. That has been affirmed time and again. First, in 1990 by the case of UST versus NLRC. And then the latest is Palgan, yan sa Bol, no? Versus Holy Name University. That in order to determine the probationary period of private school teachers, we have to refer to the Manual of Regulation for Private Schools, not the Labor Code. What is that manual all about? It is issued by the Department of Education, Culture, and Sports at that time. DepEd right now, hindi ba? And according to that, 3 years ang probationary period ng isang private school teacher. But according to UST versus NLRC, the teacher must be full-time. The teacher must have rendered 3 consecutive years of service, and the service must be satisfactory. Okay? These are the requirements so that the teacher would acquire permanent status. That's one of the few instances when the Supreme Court used the term permanent employment. Kasi normally ang ginagamit regular. Now, ang tanong natin, sino ang full-time teacher? Yung kanyang working day is devoted to the school. How long is a working day? Under Article 83 of your Labor Code, 8 hours po ang normal working day, 6 days a week. Okay? No other regular remunerative employment paid on a regular monthly basis regardless of the teaching hours, and for college teaching, it is at least 18 hours per week. That's equivalent to 18 units per week. Okay? Kaya kami mga nagtuturo sa law school, hindi kami pwedeng ma-permanent kasi kami ay part-time. That's an exception, not the rule. So, Palgan versus Holy Name University affirmed the ruling of the court in UST versus NLRC as to the requirements so that a private school teacher would acquire permanent employment status. Not the labor code, but the manual of regulation for private schools. Yan ang controlling. Okay? Hindi porke sinabing permanent ka na o regular, ay hindi ka na pwedeng matanggal. Walang forever kahit sa labor law. Okay? Under Article 297 of your Labor Code, enumerated are the causes for the dismissal of an employee even if siya ay mayroong right to security of tenure. Security of tenure lamang at hindi permanent tenure. Ano? These are called just causes. The employee has committed some serious misconduct, guilty of some fraud, okay, neglected his duties. So sabi ni employer, it's not me, it's you. Ikaw ang may mali, employee. In the case of Adamson University, Faculty Union versus Adamson University, misconduct, kasi sabi yan, serious misconduct, di ba? Is defined as improper or wrong conduct. A transgression of established indefinite rule of action. A forbidden act. But the court is also saying that if the misconduct is not serious, dismissal may be too harsh a penalty. Okay? Now, the misconduct must be in connection with the work of the employee. Because if the misconduct, no matter how serious, has nothing to do with his employment or not against the employer, that cannot be a ground for dismissal. Are we clear on that? Okay? Now, when a teacher uses expletives against the students, pinumura niya yung kanyang estudyante, would that be considered serious misconduct? In this case, according to the Supreme Court through Justice Leonen, yes, that constitutes serious misconduct. Okay? Kasi tiningnan pa yung kanyang subsequent acts, showing willful and wrongful intent, then, talaga palang parampalamura itong si teacher, so tinanggal siya. Okay? Ayan. Ngayon, you also have to understand the concept of abandonment. Abandonment is the deliberate and unjustified refusal. It is a just cause for separation from service. Why? Papasok ito dun sa letter E. Other causes analogous to the foregoing. Pag pina-enumerate sa inyo yan, pwede ba? Ito yung sinasabi ko sa mga estudyante ko. Huwag yung uunahin yung letter E. Other causes analogous to the foregoing. Maglagay naman kayo ng foregoing para hindi tayo masyadong halata. Okay? Analogous to what? Ang abandonment. Sabi ng Claudia's Kitchen versus Tangin, analogous to neglect of duty. Therefore, it is a just cause for separation from service. Now, what are the elements of abandonment? One, the failure of the employee to report for work without just or valid reason. Ayaw niya lang. Wala naman siyang dahilan. Basta ayaw niya lang. Number two, the second element according to the court, in that case of maximum protective maximum security agency versus Puentes, the second element ay yung overt acts which show that the employee has no intention to return to work anymore. These two elements must both be present in order to justify the dismissal of an employee based on abandonment. In another case, ito, nakita niyo sa screen niyo, no? Demex Ratancrop versus Leron. Mere failure to report to work is insufficient to support a charge of abandonment. The employer, it is now the employer, who must adduce clear evidence that the deliberate and justified refusal is committed by the employee manifested through his or her overt acts. As I keep on telling my students, para sa mga jowa nyo yan, ano? Di ka lang 10x maghapon, inabandon na ka na talaga. Hindi ba pwedeng wala lang siyang load? Ha? O kaya mahina ang signal? O kaya nagloko, hindi yung jowa, yung signal. O di ba? Hindi pa abandonment yan. Pero kung isang buwan ka nang hindi tinitext, hindi ka man lang pini-PM, ha? Tapos tiningnan mo yung Facebook niya, in-unfriend ka na, in-unfollow ka pa sa Instagram, blinak ka pa sa kanyang cellphone, yun ang abandonment. Okay? That was taken from Agabon versus NLRC. Remember that old case? So hindi naman umaalis dyan ang ruling ng Korte Suprema. Now, of course, you have just cause, but in order to legally dismiss an employee without violating the right to security of tenure, aside from just or authorized cause, you must observe due process. And the Supreme Court since time immemorial has been consistent in saying that the employer must give two notices. Written notice, hindi sinabing verbal notice, ano? Two written notices. That's why other jurisprudence would call it twin notice requirement. Kambal. No? So, the first notice must specify the grounds. Why should the employee be dismissed? Okay? Explain the acts or omission that prompted the employer to initiate the dismissal proceeding. Give him the opportunity to be heard. Okay? And after hearing, you give another notice, this time the notice of termination. Now, what is the reasonable time to give the employee an opportunity to explain? Distribution and Control Products versus Santos, 5 calendar days from receipt of the notice. Kasi normally, binigyan ng notice to explain. Ano? Alam na alam yung mga NTE, yung mga HR practitioner. Ano? NTE, notice to explain. Please explain in thesis writing. Wag naman, in writing. Within 48 hours, why no sanction should be imposed against you, etc., etc. For the longest time, akala nung iba yung 48 hours ay sapat na. Ang problema, sabi ng Korte Suprema ng 2017, that is not enough. You have to give ample time to the employee who is at the brink of losing his livelihood. An opportunity, an ample time to gather data and evidence and decide on the defenses he will raise against the complaint, including consulting a lawyer to protect his interest. So that cannot be done within 48 hours. So at least 5 calendar days. Maliwanag ang Korte Suprema dyan. If the employer does not give these 2 notices, the dismissal could be considered illegal. Okay, take note of that. Ngayon, binigyan ng first notice, the employee has explained. Okay? Would that be sufficient notice? Do we need hearing? A trial type hearing is not needed according to the court. Okay? A trial type hearing is not needed. For as long as you gave the employee the opportunity to explain, whether verbally or in writing, that is compliance with the hearing requirement of the law. Okay? Hearing does not mean verbal argumentation alone. Kaya lang, siyempre, alam nyo, binigyan mo ng pagkakataong magpaliwanag. Magpapaliwanag yan. And like ko sinasabi dyan, hindi ka naman talaga magiging sapat sa isang taong iba na ang hinahanap. Di ba? Yung paliwanag mo, wala na yan. Kaya nga, to your friends, you did not explain. They would understand. To your enemies, there is no need to explain. No explanation would be sufficient. Okay? And standard ito, sabi ko sa inyo kanina, the burden of proving that the termination was for a valid or authorized cause shall be on the employer. But, according to the court, the burden to prove just cause for dismissal must be met by the employer, but it is basic rule and evidence that each party must prove his affirmative allegation. Although we all know in Article 227 of the Labor Code that technical rules are not binding before the labor arbiter and the NLRC, this does not mean that the rules on proving allegation are entirely dispensed with. Why? Bare allegations are not enough. They must be supported by substantial evidence at the very least. But when employees go to the media, di ba? Are they committing any violation? Kasi gusto nila pumunta kaagad dun sa highest court of the land. Ano ba yan? Yan daw yung RTC. Paano naging highest yun? Rapid Tulfo Court. Okay? So, nagpupunta sila doon in a public forum. Aba, hindi naman ito violation unless siguro magsalita sila dyan mga mapanirang pananalita accusing the employer of anything, baka maging libelous. Why? They are fighting for their very survival, utilizing only the weapons afforded to them by the Constitution. Okay? Now, so meron na tayong just cause. The employee is at fault. Kaya siya tinanggal, walang reinstatement, walang backwages, nothing. But there is another group of causes. Ang tawag natin ay authorized causes. Unfortunately, hindi ito ninumberan o nilagyan ng letter ng Labor Code. It is just a paragraph. But from the paragraph in Article 298, we can extract the different causes for termination of employment, termed as authorized cause. Bakit authorized? The employee did not commit anything wrong. The employee is not at fault at all. It is the employer who provided the grounds for the dismissal. Therefore, meron siyang separation pay. Okay? So what are the authorized causes? Installation of labor-saving device. Other jurisprudence would call it automation. Redundancy. Retrenchment to prevent losses. Take note, there is no need for actual losses because even projected losses, if substantial, could be ground for dismissal and closure or cessation of operation. Now, in the case of samahan ng mga manggagawa sa komunikasyon, redundancy exists when the services of an employee are in excess of what is reasonably demanded by the requirements of the enterprise. In other words, mas marami ang taong gumagawa, kukonti ang trabaho. Ay natural, lugi si employer. It happened recently during the pandemic, hindi ba? When restaurants and hotels were allowed to operate 50% partial operation noong 2021 up to 2022, palagay mo yung hotel ay yung restaurant, mayroong 10 waiters. 50% na ng capacity at hindi lahat ng tao pwede makapag-dine in. At mahirap kumain sa mga panahong yon. Sapagkat habang kumakain ka, katabi mo sa X. Ang hirap sigurong kumain yan. Katabi mo sa X. Buti lang kung okay yung paghihiwalay. Ano? Yung 10, gawin na lang 5. So pwedeng i-retrench yung 5 based on redundancy. But still, kailangan may due process. Ano yung due process requirement? Still, you have to give 2 notices to the employee. Not to the employee, no? 2 notices. Bukulog dito sa amin. Sana lang wag mawala ang ating mga koneksyon, ha? Kasi ito lang talaga ang koneksyon ko, internet. The employee must receive a notice. That's the first notice. The Department of Labor Regional Office must receive a notice. So 2 notices pa rin. Kaya lang magkaiba ang patutunguhan. What is the purpose of the notice to the employee? To warn him of an impending loss of income or livelihood. Sana ganyan ang mga jowa nyo pag aalis, nagpapaalam, para makahanap ka ng kapalit. O may kapalit na bago po umalis. Pangalawa, for the Department of Labor to ascertain whether or not the grounds for termination are valid. Diba? So kailan ibibigay yan? At least 1 month before the dismissal. If you do not give it these notices, then the dismissal might be illegal. Now, citing the same case, ito ang mga requirements for compliance with due process. Number 1, written notice. Diba? Lalo na ito doon sa redundancy. Number 2, payment of separation pay. We'll discuss that in a while. Number 3, good faith in abolishing the redundant position. Kasi redundant yung position, ditanggalin mo. Because if you do not abolish the redundant position, it means it is not redundant. Diba? So if it is redundant, you abolish the position. Okay? And number 4, you have to have fair and reasonable criteria in determining what positions are to be declared redundant. Alam nyo kasi, may konsepto tayo ng unfair labor practice, di ba? Kapag inuna mong tanggalin ay yung mga tao na kaya pala natanggal dahil sa kanilang union activity, baka maging unfair labor practice yan. Okay? So take note of that. Now, employees who will be dismissed based on Article 298 ay may separation pay. How much? If it is due to installation of labor-saving device or redundancy, it is at least 1 month salary or 1 month salary for every year of service, whichever is higher. How do we interpret that? Let us give an example. Let's say naka 9 months employee pero tatanggalin siya based on redundancy. 9 months pa lang. Oo nga, kasi wala pang 1 year. A fraction of at least 6 months is considered 1 whole year. So may 1 month salary siya. Kasi nalagpasan niya na yung probationary period na 6 months, kaso natanggal because of redundancy, di meron siyang 1 month salary. 1 month. Naka 4 years siya. After 4 years, tatanggalin siya because of redundancy, for example, then he has to receive 4 month salary. Doon mag-a-apply yung 1 month salary for every year of service because that is higher than 1 month salary. Now, if the ground is retrenchment to prevent losses or closure of operation, then it should be 1 month pay or 1/2 month salary for every year of service, whichever is higher and a fraction of at least 6 months is considered 1 whole year. Using the same example, 9 months, 1 month salary pa rin. Naka 4 years, 2 months salary kasi for every year, 1/2. So 4 na 1/2, di 2 months. Di ba? O yan. Why? Maawa naman kayo, nalulugi na nga kaya siya nagsarado. Ha? Tapos, isingilin nyo pa ng malaki. So it's just 50%. That's reasonable. Okay? So, in the case of samahan ng mga manggagawa sa komunikasyon, separation pay is required. Why? For dismissal yan under 298 and 299. 299 this is. We'll discuss that in a while. This is designed to provide the employee the wherewithal during the period that he is looking for another job. Para may magastos naman siya. Dahil naghahanap siya ng bagong trabaho. Okay? Now, teka. Bakit napunta dyan? Okay. So, the amount of separation pay is based on 2 factors. The amount of monthly salary and the number of years of service. Take note, the employer is not required to pay separation pay if the closure is due to serious business losses or financial reverses. Okay, that is the only time that the employer are not compelled by law to give separation pay. Matagal na yata separated yung dalawang yan. Ano? But remember, the burden of proving serious business losses is with the employer. The employer must show proof that losses on the basis of financial statement covering a sufficient period of time. Unfortunately, jurisprudence did not tell us what or how long a sufficient number of time. Okay? Si employer pa rin magpo-prove na talagang nalulugi siya for a long period. Now, what about the case of ineffectual dismissal? Ineffectual dismissal happens if there is cause for the dismissal, whether just or authorized. But the employer did not observe due process or violated the employee's right to due process. So ano mangyayari dito? Walang reinstatement, walang backwages, no separation pay, but the employer must pay nominal damages. How much is nominal damages? It depends on the court. If you would read the case of Agabon versus NLRC, there was just cause, abandonment. But the employer gave just one notice. Notice of termination to the employees. Dalawang employee, mag-asawa yan, Jenny and Virgilio Agabon. Okay? Now, there was just cause. But there was just one notice in violation of the twin notices requirement. The court awarded 30,000 nominal damages. In the case of Duka versus Pakot, it was based on authorized cause. But the employer violated the right to due process notice requirement. The court awarded 50,000 because the employee is not at fault. Take note also of the concept of constructive dismissal. It happens when the continued employment is rendered impossible, unreasonable, or unlikely as an offer involving demotion in rank, di ba? Ayaw mo magpa-demote. O kaya violation ng right against diminution of benefits. It is called dismissal in disguise. Constructive dismissal occurs when the employee ceases to report for work. But when the unwarranted acts are committed to the end that the employee's continued employment shall become intolerable. Okay? Ayan. In the case of Palco versus LBC, ito naman ay kaso ng sexual harassment. Inireport niya na yung kanyang employer, inireport niya yung kanyang supervisor sa kanilang employer sa main office na hinaharas siya sexually araw-araw ng kanyang supervisor diha sa Cebu. Oh, wala ginawa. Hindi man lang siya tinulungan ng kanyang employer. Miss Palco, hindi Dis Palco, Miss Palco resigned. After resigning, she filed a case for sexual harassment against the supervisor. At the same time, filed a case of illegal dismissal. Ang sabi ng employer, there was no illegal dismissal because you resigned. Ano sabi ng Korte Suprema? An employee is considered constructively dismissed if he or she was sexually harassed and her employer failed to act on his or her complaint with prompt and sensitivity. Ilang buwan na yung kanyang complaint, hindi inaksyonan, siyempre natatakot siya, nayaharas na naman siya, so nag-resign. That is a case of constructive dismissal, therefore illegal dismissal and not resignation. However, when strong words from the employer happen without palpable reason, and expressed only for the purpose of degrading, kasi may mga employer talagang nang-iinsulto ng empleyado, no? So pagka ganyan, iyuyura ka ng dignity mo, Eh kahit mag-resign ka, baka po pwede na ito ay maging constructive dismissal. Okay? Now, unemployment may also be terminated. Please do not terminate the employee. Ha? I warned my students yesterday, do not terminate the employee. Terminate the employment. Because if you terminate the employee, ay walang jurisdiction sa labor arbiter as it is a case of murder or homicide as based on the circumstances. No? So you terminate the employment. Now, an employee who is sick may be dismissed based on Article 299. But according to the court, the employee suffers from a disease which cannot be cured within 6 months. And the continued employment is prohibited by law or detrimental or prejudicial to the health of the employee or the co-worker. Mag-isip kayo ng sakit na ganyan. Hindi po UTI, ha, yung umibig tapos iniwan, ibang sakit yun. Na hindi napapagaling within 6 months despite medication. And letter B, there must be certification to that effect coming from a competent public health authority. So material yung certification na yan. That is also contained in an earlier ruling based on the implementing rules of Book 6. Okay? Pag nawala yung isa dyan, illegal yung dismissal nyo. And take note, an employee who is dismissed based on disease is entitled to separation pay, the amount of which is equivalent or the same as the separation pay for dismissal based on retrenchment or closure. Meaning, 1 month salary or 1/2 month salary for every year of service, whichever is higher. Okay? Ngayon, puntahan natin yung Article 300. Ito yung putting the employee on a floating status. That should not exceed 6 months according to Article 301. In 2020, the Secretary of Labor issued Department Order 215. Kasi nga, COVID itong panahon na ito, no? So allowing the extension of floating status for another 6 months. Is that extension valid? The Supreme Court said, no. The practice of placing security guards, kasi sila normally ang ganyan, di ba? Dahil walang mapag-assignan na bagong establishment, so floating muna sila. But that should not exceed 6 months. Why? According to the Supreme Court through Justice Leonen, beyond this, a security guard's floating status shall be tantamount to constructive dismissal. Okay? So hindi po pwede because if we allow the Secretary of Labor to extend that, we are allowing the Secretary of Labor to amend the law. Kaya lang kung babasahin na yung Department Order 215, very subtle yung pagka-craft. It did not even refer to Article 301 because it would be referring to Article 301, mate-technical sila because the Secretary of Labor cannot amend the Labor Code. Only Congress can do that. Okay? Now, let us summarize. If there is just or authorized cause for the dismissal, there is due process, the dismissal is legal. If the dismissal is legal, there is no reinstatement, no backwages, nothing. Okay? Legal eh. Now, if there is no cause, the employer did not observe due process, the dismissal is illegal. Alam nyo na ang remedyo pag illegal dismissal. The employee is entitled to reinstatement of the former position without loss of seniority rights, plus back wages, plus damages, and do not forget attorney's fees based on Article 111 of the Labor Code that should not exceed 10% of the wages recovered. There is no cause, but the employer observed due process. What happens to the dismissal? Still illegal. The presence or observance of due process cannot cure the defect of lack of cause. Now, there is cause, but the problem was the employer did not observe due process or the right to due process was violated. The dismissal is neither legal nor illegal. It is ineffectual. Okay? So pag sinabi natin ineffectual, no reinstatement, no back wages, but the employer must pay nominal damages because according to the Supreme Court, that is to avoid the practice of dismiss now and pay later. Okay? Now, siyempre, if the dismissal is illegal, kahit minsan legal, pumupunta pa rin yan sa NLRC. So alam niyo naman ang procedure dyan, hindi ba? But let me just tell this to you, nadadaan muna tayo dun sa SENA. Ano ang basehan ng SENA sa Labor Code? Article 234 as amended by Republic Act 10396. Ano yon? Mandatory conciliation. Baka magkasundo. Okay? So, within 30 days yan, based on Department Order 107, Series of 2010, within 30 days, baka magkasundo. With or without jurisdiction, yung agency, magkakandak siya ng mandatory conciliation. Therefore, based on this rule, no labor cases can be dismissed if the only ground for dismissal is jurisdiction or lack of it. So, nagkasundo sa SENA, well and good. Hindi nagkasundo, within 30 days, the hearing officer should refer it to the agency who has jurisdiction. So let us take a look at this. So kay labor arbiter, assuming it was illegal dismissal. The labor arbiter under Article 224 of the Labor Code must decide within 30 calendar days from the time the case is submitted for resolution. For OFWs, this would be shorter because that's 90 days from the filing of the complaints. Okay? Now, kay labor arbiter, magkakaroon din niya ng mandatory conciliation. And then, the decision of the labor arbiter is not subject to motion for reconsideration. You do not file a motion for reconsideration from the decision of the labor arbiter. What do? You appeal to the NLRC within 10 calendar days from receipt of the judgment. Natalo pa rin sa NLRC, you file a motion for reconsideration to the NLRC within 10 calendar days again from receipt of the judgment. Okay? Now, natalo pa rin, of course, you should know the requirements for the perfection of an appeal. Depende kung sino ang nag-aapila. If the appellant is the employer, he has to post bond equivalent to the amount of monetary award exclusive of damages and attorney's fees. Now, NLRC, natalo pa rin, tayong MR na dismiss, you go to the Court of Appeals, you file a petition for certiorari under Rule 65, you have 60 calendar days to do that. Now, we all know, particularly yung mga iba sa inyo na nasa fourth year, alam nyo na ang civil procedure, at yung hindi pa nakakaalam, alamin nyo, that when you file a petition for certiorari under Rule 65, it will not stop the running of the period. What do we mean by that? Hindi titigil yan, magiging final and executory. Therefore, kung may monetary award, makakapagpa-execute kayo even pending appeal. That is allowed by the rules of the NLRC and supported by jurisprudence. So anong gagawin para hindi sila makapagpa-execute? You ask for an injunction from the Court of Appeals following the procedure under Rule 58. Convince the appellate court that there will be grave irreparable injury that the party may suffer if an injunction is not issued. Kasi pag hindi nag-issue ng TRO, tapos ang boxing. Pag naging final and executory, nakatanggap itong complainant ng entry of judgment, notice of entry of judgment, ay magpapa-execute yan. Meron pa ho kaming certiorari. Ang tanong ko lang dyan, nakakuha ka ba ng TRO? Kasi kung wala kang TRO, execution pending appeal is allowed even by jurisprudence. Okay? Natalo sa Court of Appeals, mag-motion for reconsideration, talo pa rin, you go to the Supreme Court, you file an appeal, and it is an ordinary appeal, Rule 45, petition for review on certiorari. Take note, you only have 15 calendar days to do that, and on pure questions of law. Because the Supreme Court is not a trier of facts. Okay? So, sometimes, ito naman si employee ang talagang gusto nang bumitaw. Di ba? Pwede naman mag-resign by giving a notice at least 30 calendar days or 1 month in advance. Pero inyo, may mga employer pala na ang nire-require ay 60 days. And the other day, yung aking nephew na piloto, 180 days daw ang pinagre-render sa kalahap. Kung legal yan. Ganyan na ba kayo ngayon sa airline industry? Sabi, yun na nga po eh. Ha? Kasi daw, iba-blacklist sila. So, what kung iba-blacklist ka? Di ba? The labor code must prevail over a company policy. Oh, masyado kasi nang o-oppress minsan ng ibang kumpanya. It should be 1 month, not 180 days as required by that airline company. Ilan lang naman ang airline sa atin, ano? Okay? Now, the employee may dispense with the giving of notice if there is serious insult. Ininsulto ka ng todo-todo. Oh, according to the Supreme Court, ito ang sabi ni employer, sabi ni employee, ininsulto siya. Eh sabi naman ng Korte Suprema, as in every human relations, there are bound to be disagreements. Ano ba sinabi sa'yo ni employer? Ito ang sinabi. Kung ayaw mo na, ng ginagawa mo, we can manage. Aba, na-insulto ka na. Grabe ka naman ka-sensitive. Sabi ng Korte, hindi naman siguro sapat yan para sabihin mo that there was serious insult. Okay? Next. Inhuman and unbearable treatment. Ito, tulad ng mamang ito, pinagpapala pero hindi naman masaya. Eh hindi naman kasi lahat ng masaya pinagpapala, ano? O pinagpapala masaya ka. Eh ano, tanghaling tapat pinagpapala ng semento. Hindi naman po pwede yan. Then commission of a crime, as in the case of Palco versus LBC. Why? Abay, harass siya sexually. Sexual harassment is a crime. And this is one of the first cases where the Supreme Court affirmed and applied legally the Safe Spaces Act, Republic Act 11313. Kaya mag-ingat because of the Safe Spaces Act. And then, other causes analogous to the foregoing. Ito ang palaging tinatanong, hindi ng mga magbabar, kundi ng mga empleyado na nag-resign. Kapag ka ako po ba ay nag-resign voluntarily after 10 years, bumitaw na ako, am I entitled to separation pay? The general rule is no. Voluntary resignation does not deserve payment of any separation pay. Exception to that rule is if there is an employment contract, providing for payment of separation pay when the employee resigns, or it is a CBA policy, or it is a company practice. Okay? Now, take note that in resignation, illegal dismissal cases, when the employer raises the defense of resignation, the burden to establish the voluntariness of such resignation rests on the employer. Bakit? Eh sabi ng employer, nag-resign si employee. Sabi ni employee, nag-resign po ako kasi napilitan lang ako. So who has the burden? The employer must prove that there was no compulsion in the employee when he or she resigns. Eh teka muna, may employee na nag-resign ngayon. Pero kaya pala siya nag-resign kasi nagpapapigil o kaya nagpapa-increase ng benepisyo. Oh, eh binawi. Pwede pa ba? Sabi ng Korte Suprema, as early as 1997, resignation once accepted may not be withdrawn without the consent of the employer. Eh, nag-resign ka na eh, tinanggap na yung resignation mo. Tapos na-realize mo, hindi mo pala kayang bumitaw. Binawi mo. Sabi ni employer, ayoko na. Resign ka na eh. Nag-file lang kasong illegal dismissal. Sabi ng Korte Suprema, hindi naman yan illegal dismissal. Kasi nag-resign ka na eh. Kaya bago mag-resign, pag-isipang mabuti. Huwag kang magpapapigil kung alam mong hindi ka naman pipigilan. Okay? Ayan. So, alam nyo, lahat ng bagay may hangganan. Pero hindi pa dito matatapos ang ating discussion. Under Article 302, as amended by Republic Act 7641, the retirement pay law, the employee may retire at the age of 60 to 65, provided he has served at least 5 years in the establishment. The law did not say whether it is continuous or broken. Now, ano ang entitlement niya? 1/2 month salary for every year of service. A fraction of at least 6 months is considered 1 whole year. And according to the law, yan po ay 15 days plus 1/12 over the 13th month of the 13th month pay plus 5 days service incentive leave. Teka muna, yung service incentive leave under Article 95, ini-enjoy niya na yan. Entitled pa rin siya dyan. Okay? Therefore, in the case of Capital Wireless versus Confessor, that is equivalent to 22.5 days salary for every year of service. Take note, this is one-time payment. Okay? In the absence of a retirement plan, ito po yan, ano? In-affirm ng Korte Suprema, yung nakalagay sa Labor Code. In that case of Pulong versus Super Manufacturing Incorporated, ito ay 22.5 days. Itinatanong ng iba, bakit po naging 22.5? Kasi yung 1/12, that is equivalent to 2.5 days. Bakit yan 2.5? Mga estudyante ko, alam yan. Ano? Kasi, that is based on the actual computation of the 13th month pay. Under Presidential Decree 851 as amended, ang 13th month pay ay ganito. The salary for 12 months, so 12 divided by 12. Okay? Kung ano yung lalabas na quotient, yun ang 13th month. Kaya parang kung consistent ang sweldo mo, 1 month salary yun. Kung consistent. Now, ang sabi dito, 1/12. So yung 12, gagawin mong 1. And that is equivalent to 1 month. So 1 month, if not designated by its name, ano sabi ng Article 13 ng Civil Code? Presumed to be containing how many days? 30 days. So 30 divided by 12 will give you 2.5. Kaya 2.5 days. Yan. So total 22.5. One-time payment. Based on Enriquez Security versus Kabotahe, ito ay based on the latest salary before the employee retires. Magkano sweldo niya bago siya nag-retire? Yun ang basis ng 22.5 days for every year of service. Sino magbabayad? Si employer. Because the employee is not required to pay for his retirement. In the case of Aninyon versus GSIS, retirement laws are liberally construed in favor of the retiree beneficiary, not in favor of the employer. Okay? So retirement age, however, for underground and surface miners ay mas mababa, 50 to 60. Okay? Of course, ganun din ang entitlement nila. You have to understand bakit mas maaga ang retirement nila. Kasi naman yung nature ng kanilang trabaho, nasa ilalim sila ng lupa eh. Bihira na arawan yan. Now, ganun din ang kanilang entitlement. And remember, retirement plan must be fair. In the latest case of Halagenya versus Philippine Airlines, January 10, 2023, considering the constitutional guarantee of protection to labor, ano ba kasi ang issue dito? Pinaparetiro ng Philippine Airlines yung kanya mga male flight attendants at the age of 60. Female flight attendants at the age of 55. Nakalagay yan doon sa kanilang collective bargaining agreement. Okay? Question ito ng mga female flight attendants. And the Supreme Court said that is invalid. The retirement age must be 60 to 65. 65 is mandatory and you cannot discriminate between women and men employees. So pareho dapat yan. Okay? And retirement must be voluntary. Okay? May mga employees na nire-require na magretiro ang employers. They are requiring their employees to retire at the age of 60. Take note, required. The problem is, according to the court, that is not allowed. Compulsory retirement is equivalent to illegal dismissal. Why? If the employee thinks that he can earn more by working rather than retiring at the age of 60, he or she cannot be compelled to retire at the age of 60. Retirement at the age of 60 is voluntary. So where do we get the voluntariness? Consent of every employee. Kahit po nakalagay na sa CBA, yes, the employee who wants to retire at the age of 60 must do it voluntarily. Otherwise, Hakulbi versus Silliman University, nasa kabila ng inyong isla, sa Bacolod, constructive dismissal yan. Okay? Now, Hindi pinagbabawal ang contributory retirement plan. Pwedeng mag-contribute sa retirement plan ng employee. However, at the time of retirement, the contributions made by the employee, as in the case of Santa Catalina College versus NLRC, must be deducted first before you compute the 22.5 days for every year of service. Why? Nangyari kasi dito, pati yung contribution ng empleyado, sige, sa'yo na lahat yan. Eh, nung kinompute yan, teka muna, 50% nito contribution ko eh. Ay, di yung kulang, kailangan bayaran ng employer. Because the employee, as I said earlier, is not required to pay for his retirement. It is the obligation of the employer. Now, are we entitled to retirement pay? Katulad ko ng mga part-time faculty members. The answer is yes, according to De La Salle Araneta University versus Bernardo. Because the retirement pay law, particularly Republic Act 7641, did not distinguish as to the kind of employees who are entitled to retirement pay. Of course, kung ikaw ay part-time, natural, maliit ang retirement pay mo kumpara doon sa mga full-time. But that does not give the employer the excuse not to give retirement compensation to part-time workers. Okay? And finally, in Book 7, hindi pa ito matatapos, magbe-break lamang tayo, hindi pa naging tayo, magbe-break tayo for a short period, and then we'll continue hanggang alas 5 po ang kontrata nyo sa akin. Okay. Article 291, which is now Article 306, provides for prescription. All money claims enumerated in your screen, Ariola versus Filipino Star ngayon, all money claims prescribed in 3 years. According to Article 306. And then ang sabi ng Korte Suprema, in that case of protective maximum security, and that includes money claims of seafarers. But the provision does not include money claims based on illegal dismissal. Kasi as a consequence of illegal dismissal, you have backwages and damages. And these are money claims. But these are not covered by the 3-year prescriptive period. Why? An action for illegal dismissal according to the Supreme Court in that case of Gallego versus Walem. Walem po yan, hindi wallet ha. Baka wala ng pera ito kaya ginawang wallet. Walem yan. Walem Maritime Services. Kamali ng typing. It is a complaint for injury to rights. What right is injured in illegal dismissal? Victory Liner versus Rase, that is an injury to your property rights. Okay? Therefore, it is covered by Article 1146 of the Civil Code and not by Article 306 of the Labor Code. So may money claim ang illegal dismissal, di ba? Backwages, damages, attorney's fees. But they are incidental to the main cause of action, which is illegal dismissal. Therefore, the prescription period for illegal dismissal, including these kinds of money claims, incidental to illegal dismissal, is 4 years. Based on 1146 of the Civil Code. Okay? Now, that was also the ruling of the court in that case of protective maximum security versus Fuentes. Prescription period for illegal dismissal, therefore, is 4 years, according to this old case, Calianta versus Carnation. The prescription period for service incentive leave under Article 95 of your Labor Code is 3 years. Kaya lang, the start of the prescription period is at the time the employee demanded for the payment of this kind of money claim. Example, the service incentive leave of this employee was not paid in 2018. 2018, hindi siningil. Hindi rin mabinayaran ng employer kasi alam niyo, employer, pag hindi ka naniningil, hindi minsan binibigay yan. It's now 2023. 5 years na nakaraan. No? The employee resigned at naalala niya, hindi niyo pa pala binabayaran yung service incentive leave ko noong 2018. Sabi ni employer, hindi na, nag-prescribe na yan. The court does not agree with this. Why? The prescription period starts only this time, 2023, when the employee demanded for that compensation. Okay? So all money claims prescribed in 3 years, not 4 years, and not 10 years. Yan ang sabi ng Korte Suprema in that case of Laureano versus Court of Appeals. Kasi doon sa 1144 ng Civil Code, 10 years 1146, 4 years. Pero if it is pure money claims based on employer-employee relationship arising out of employer-employee relationship, the prescription period is 3 years. We follow the special law, particularly Article 306 of the Labor Code. Okay? And that right to unionize is both a constitutional and statutory right. No? Yan ay nasa Article 3, Section 8 of your Constitution. I did not read that to you. Now, when anyone, employer or employee or union or anybody interferes with that right of the employee, it's called unfair labor practice. Okay? But according to the court, the definition under Article 219 does not give us anything but a mere repetition of the same term. Ano sabi doon? Unfair labor practice means any unfair labor practice as expressly defined by this code. Wala. May repetition of the same term lamang ito, no? By the way, nandito rin pala mga estudyante natin sa San Sebastian, sa PUP, sa PLM, at saka sa Manila Adventist College. Mabuti at naririto kayo at hindi mababawi ang mga grades nyo. So, unfair labor practice is any act of the employer, the union, officers or members that interferes with the right of the employee to join or not to join a union. No matter how unfair, if it has nothing to do with the right to unionize, do not call it unfair labor practice. Okay? Now, unfair labor practices are violative of the constitutional right of the workers to self-organize. Maliwanag ang sinasabi ng Adamson University case. But we look at the totality test, yung kabuuan, to determine whether or not it is really unfair labor practice. When a union officer is dismissed, general rule, it is called unfair labor practice, the worst kind, union busting. Mga kaibigan din natin sa Bohol, ano? Narito rin pala sila. Hindi ko lang mabanggit isa-isa dahil napakarami ninyo, baka maubos oras natin. But my thoughts are with you. Thank you for attending this seminar. Teka, ba't ako nagtithank you para sa inyo to? Joke lang. Okay. So, when you dismiss a union officer, general rule, yan po ay union busting. But according to Justice Leonen, in this case of Adamson University, a dismissal of a union officer is not necessarily discriminatory, especially when that union officer committed an act of misconduct. Why? In fact, union officers are held to a higher standards. Diba? Leader ka eh. May mga employer na papapirmahin ka muna ng kontrata na hindi ka sasali sa union para magtatrabaho ka. Under jurisprudence, it is called yellow dog contract. Bakit? May problema talaga kayo sa mga dilawan? Why? Yung yellow kasi neither hot nor cold. Diba? Paano naman yung dog? Lagi na uuntog yan. Dog, diba? Hindi. Yung aso daw kasi pagka binigyan mo ng pagkain, no matter how ferocious, bumabait. Yellow dog, sinurrender mo. Okay, hindi dapat pinapakain. Di ba yung mga nag-handle ng K9? Although nagre-reklamo, bakit daw K9? Siyempre, aso yan eh. Pag K10, pusa na yan, hindi ba? Ayan. Okay. So, nandito pala si Attorney Donna. Okay. Ayan. Now, what about a runaway shop? Ito tumatakbo. Alam nyo, sa Amerika kasi, iba't ibang estado, iba-iba ang labor law nila. So in one state, mahigpit, in another state, hindi. So lilipat siya doon. But in our country, common naman ang labor laws natin. Nagkaiba lang siguro doon sa minimum wage. Because the minimum wage in every region is dictated by the regional wage board. So, ngayon, itong runaway shop na ito, lumilipat siya, yung company, no, lumilipat in another location, una, para iwasan yung union activities. Pangalawa siguro, para maiwasan yung mga matataas na mga state regulation. Let's say, for example, may branch siya dito sa Metro Manila, tingin ni employer magi-strike na. Meron din siyang branch doon sa Laguna, that's another region, di ba? Calabarzon yan. So, ang gagawin niya, ililipat niya doon sa Calabarzon yung kanyang operation para mag-strike man kayo dito sa Metro Manila, tuloy yung operation ko. We call that runaway shop. Okay? That's unfair labor practice. What about blue sky? Hindi ito yung kalaban ng Skyflex as I used to joke with my students. Ano? Blue sky bargaining is demanding too much. Masyado ng malaki ang hinihingi. Diba? Unreasonable proposal. If you look at the sky and it is summertime, it's blue, it's very high. But if there are clouds, that is not high. Okay? So blue sky bargaining, let's say for example, during negotiation, ang gusto ng employee, ng union, itaasan ang sweldo nila. Minimum wage daily ay gawing 1,000. Teka muna, sa Metro Manila pa lamang, Metro Manila na, pinakamataas itong minimum wage ay 570. Gusto mo 1,000? Sabi ni employer, no. I'll give you an increase of 10 pesos. Take it or leave it. Ayan naman ay bulwarism. Galing yan kay Lemuel Boulware. Ayan, nakikita nyo yung libro dyan sa inyong The Truth About Bulwarism. That is a take it or leave it stand. This is the best and last offer I could give you. Take it or leave it. Kung ayaw mo, diwag. Okay? Now, during bargaining, another unfair labor practice ay yung surface bargaining. They go through the motion of bargaining without the intention of really entering into an agreement. What is the product of good collective bargaining? The CBA, good CBA. Diba? Surface bargaining is going through the motion. Parang Ferris wheel, sabi ko sa mga estudyante. Kala mo pinapaligaya ka, yung pala pinapaikot-ikot ka lang, wala kayo patutunguhan. Para ka nakasakay sa isang rocking chair. Bakit? Galaw ka ng galaw, pero wala ka namang nararating. Ganyan ang surface bargaining. Okay? So wala lang, gusto nyo lang mag-bargain pero wala namang kayo patutunguhan. Oh. Ngayon, what about feather bedding? That's also another form of unfair labor practice that is committed by the union against the employer. Article 260 paragraph D. Ang union nangihingi ng bayad for a service that is not to be performed or requiring the employer to hire more workers para magaan ang trabaho nila. That's feather bedding. Okay? But if work is performed, no matter how trivial, you cannot consider that feather bedding anymore. Palagi kong ginagawa example dyan, yung pipinturahan yung building, hindi pininturahan, ay feather bedding yan, binayaran na kayo eh. So nangikil lang kayo. Now, pininturahan naman, kaya lang po siya. Anak ng pusa naman. Ang usapan natin, blue, bakit pusa? Diba? Hindi na feather bedding yun. May ginawa siya eh. Bakit ba kasi feather bedding? Nung hindi pa uso ang paggamit ng cotton sa Amerika, yung mga colonies ng Amerika, yung 13 colonies dati. Kasi hindi pa nila na-discover yung pagtatanim ng cotton at ang mga nagtatrabaho sa cotton field, yung mga African-American slaves. Uso ang slavery noon kahit naman saang lugar. No, kung wala pang cotton, ang ginagamit nila feathers. So yung bedding mo, lagyan mo ng maraming feathers para maging comfortable. Kaya doon kinuha yung feather bedding na yan. Gusto nila maging komportable ang buhay nila at the expense of the employer. Aliwanag. O, kayo ba ay may sweetheart na? Ha? Tandaan nyo, lahat ngayon nagmamahal. Kayo ba nagmamahal na? O, kaya namimiss ko si Presidente Duterte. At least nung panahon niya may nagmumura. Ngayon lahat nagmamahal. Okay. So ito naman, under Article 260 paragraph E, yung mga nag-a-attend ng bargaining, hindi naman kasi lahat na miyembro ng union o officers nag-a-attend yan. Yung mga nagpa-participate sa bargaining, binayaran, binili, binigyan ng kung magkano man. Siyempre, pag nabayaran, hindi na yan ihirit. So kung anong gusto ni employer, yun ang matutupad. Diba? So that is sweetheart's contract. It will not improve. It will not improve the life of the employees. Bakit? Ang binayaran lang yung mga negotiators. Okay? Now, sino ba talaga ang nagbabargain? Tandaan ninyo palagi. Ang labor code kasi napakaganda ng arrangement. Pinag-uusapan na yung bargaining, hindi mo pa alam kung ano yung bargaining unit. Under Article 267, a bargaining unit is a group of employees. let us do away with this technicality. A bargaining unit is a department. Ang palagi ko example sa mga estudyante ko dyan, and I'm not giving this to you, in a school setting, lahat tayo duman sa eskwela, kaya nga kayo nakagraduate eh. Sino ba ang mga bargaining units dyan? Eh di yung mga teachers, kami. What bargaining unit kami? We should be represented by a union. Non-teaching personnel, pero academic, yung mga nasa office. Oh, they should be represented by a union kasi one bargaining unit yan eh. Di ba? So a bargaining unit is a department. And the union representing the bargaining unit is the bargaining representative. Eh pwede ba na isang bargaining unit, marami ang gusto mag-represent? Natural. Kaya nga nagkakaroon ka ng certification election. Diba? Kasi hindi natin, kasi ganito yan eh. Halimbawa, nung una isa lang ang union. Oh, sa Pilipinas, ang union naman, dapat nakarehistro sa regional office. If it is operating in more than one region, you go to the Bureau of Labor Relations as required by Article 240 of your Labor Code. So, rehistrado na. Pag narehistro nyo ang union, ang tawag na natin dyan ay legitimate labor organization. It has the personality to participate in certification election. If it won in the certification election, it can bargain with the employer representing the bargaining unit. Alam nyo na, ha? Ngayon, may union, may constitution and bylaws. Siyempre, may opisyal. Tumakbong, magkakaroon ng eleksyon. Siyempre, hindi naman for life yan. O, tumakbo si A bilang presidente ng Union X. Tumakbo rin si B. So, A and B running for president. Nanalo si A. Siyempre, si B hindi natalo, dinaya yun. O, di ba? So, anong gagawin niya? Mag-file yan ng appeal. Hindi election protest ang tawag. Appeal. I-appeal niya yung result ng election na yon. Saan? Sa Bureau of Labor Relations. But take note, sa real life, sa tunay na buhay, sa regional office yan, meron diyang Labor Relations Division. Okay? Alam ito ng mga nagtatrabaho sa Department of Labor. Ang sabi ng BLR, ay legal yung election eh. Hanggang sa maging final sa Supreme Court. So si B, wala na, saving face na, no? Magtatayo din siya ng sarili niyang union. Is he prohibited from establishing a union of his own? No. For as long as he can comply with the requirements of Article 240, kaya importante yan. But for lack of time, ay hindi na natin dadaanan ng isa-isa pa, no? Dahil ang presumption natin dito, alam na ninyo ito. That's the mistake of many law students. Entering a law school classroom without knowing anything. Wrong. You are committing suicide. Why? Contrary to your college classroom, kaming mga professor sa law school, when you enroll in our class, our presumption is that you know. We do not give you lectures, we ask you questions. Sabi yung gagaling ng mga lecture namin. Kasi nagle-lecture kami. Pero yung mga professor nyo, hindi naman required na mag-lecture eh. Yan ang tatandaan ninyo. Yan ang downfall ng maraming mga law students eh. Expecting na pagka pumasok ako sa classroom ng professor sa law school, tuturuan ako. Hindi po. Tatanungin namin kayo. Doon kayo ginegradean sa naisasagot ninyo. Hindi doon sa nakalimutan nyo. Ha? At saka pag-iusap ko sa mga estudyante ko, in my classroom, do not call me attorney. Ha? Call me sir. Kasi hindi naman ito attorney-client relationship. This professor-student relationship. Outside my class, ngayon, pwede nyo ako tawagin. Anything you want to call me. Just don't call me baby unless you mean it. Okay? Joke lang yan. Okay, maliwanag. So, nagtayo ng union itong si B. Ay di dalawa na sila. O ngayon, sinong kakausapin ng employer sa kanila to represent the bargaining unit? Yun, magsi-certification election. Now, anong kaiba ng certification election sa consent election? Certification election, you file a petition. Saan? Sa regional office. Consent election, gentleman's agreement. Yung mga union, kayo na lang. Hindi na kayo magpa-file ng petition. Kung sino manalo, igalang nyo. Now, how do you win in a certification election? By getting the double majority vote. Okay, double majority. Saan po manggagaling ang first majority? The majority of all the members of the bargaining unit must vote. Ano yung bargaining unit natin kanina? Teacher. O sige, palagay natin, faculty members. Dalawa yung union na gusto mag-represent sa mga teachers. Tawagin natin Union X and Union Y. Mas gusto nyo ba si X o si Y? Naku, mahirap si X, no? Problema yan kaysa tunay na buhay. Okay. Di sila ang nag-file sila ng petition, that is certification election. Ilan teachers ito? 100 teachers. So ilan ang dapat bumoto to get the first majority? At least 51. Why 51? 50% plus 1. Okay? Eh paano po kung ang bumoto ay 49 o 50? Hindi bumoto yung 50 because we cannot compel them to vote. Walang compulsion dito. Pag ayaw niyong pilitin, masasaktan ka dyan. Eh, idideklara ng election officer ang failure of election. Because less than the majority voted. What is the effect of declaration of failure of election? Then, anyone may file another petition for certification election within 6 months from the declaration of failure of election. Okay? Now, where do we get the second majority? So okay na tayo sa first majority. Where is the second majority? The union who got the majority vote of those who voted shall win. In other words, ito example natin, there were 100 employees in the bargaining unit. There were at least 51 voted. No? So that's the first majority. I-distribute natin. Kailan dito maraming unions A, B, and C. Oh, yan ang distribution. Meron bang kulang? Meron. Because no union is always a choice whether in a certification or consent election. Why? The right to join a union includes the right not to join a union. Okay? So total natin yung boto, 51. O may nanalo ba? Nobody won. There is no winner. Why? Wala naman nakakuha ng majority. What is the majority of 51? 26. Is there a union who got 26 votes? There is none. Therefore, there is no winner. Okay? So ano mangyayari kapag kaganyan ang resulta? There will be a run-off election. Okay? But the question in 2006 bar exam, can a no union win in a certification or consent election? Yes. If it got the double majority votes. Okay? Oh, kaso nga, hindi nakakuha 20 lang ang nakuha niya. Kailan magkakaroon ng run-off election? Run-off election occurs when there is a certification or consent election with at least 3 or more choices. Kasi pag isa lang ang union, wala ka ng eleksyon. Pag dalawa ang union, may election ka pero 3 ang choices mo. What is the third choice? No union. No union is always a choice in a certification or consent election. Okay? So yung dalawang unions who garnered the highest number of votes in the certification election in our example will have another bout between unions A and B because they were the unions who garnered the highest number of votes. Teka, sabi ng mga bumoto sa no union, dapat kami kasi kami ang pinakamaraming boto, 20. Wrong. Why? No union is no longer a choice in a run-off election. Why? Kasi kung gusto ng majority na walang union, nanalo na sana yung no union. Okay? Nakakuha sana ng 26. Eh since hindi siya nakakuha ng 26, and if you look at the total number of those who voted for a union, that is more than 50% of all the votes. Therefore, magkakaroon ng runoff between the two unions who garnered the highest number of votes. Kasi ang tanong sa certification or consent election, which union, do you want to have a union? Which union? Pero dito sa run-off election, ang tanong na lang, which union do you want? Hindi ka na tinatanong kung gusto mo ng union. Bakit? Majority ang gusto may union. They cannot just make up their mind which union they prefer. So ang tanong, yung bang mga hindi bumoto sa certification or consent election, pwedeng bumoto sa run-off election? Yes, they can. Because we want to have the majority. Remember, the union who would win must have the majority vote of all the members of the bargaining unit. Otherwise, plurality, hindi siya mananalo. Okay? Now, Department Order 40-1-15 introduced the concept of rerun election. Ano ba yung rerun election? Pagka nagkaroon ka ng certification, consent, or even run-off election resulting into a tie, hindi ka na magpapile ng petition. Ang gagawin na lang ng election officer ay i-announce niya within 5 days na merong tie and within 10 days merong nakaschedule na another election. Ayan yung rerun election to determine who would win. Okay? That's a new concept under Department Order 40-1-15, Section 16. You can download that from Google. No? Okay. So pagka kayo ngayon ay nanalo na kung sino yung nalaman na, sino makikipag-bargain kay employer, ang tawag na sa kanya ay Certified Exclusive Bargaining Agent. Certified, bakit? Kasi nanalo siya sa certification election. Kaya huwag niyong tatawagin certification of election. That's very wrong. Okay? Certification election because the winner shall be certified as exclusive bargaining agent, SEBA with a C. Kasi kung mag-isa lang siya, ang tawag ay SEBA pero with an S. Sole and exclusive bargaining agent. Bakit sole? Eh mag-isa lang siya. Oh, pagka ba dalawa, wala nang kaluluwa. Iba naman yan, sole yun. Nasa Korea yun. So what is a collective bargaining agreement? It is a contract between the employer and the bargaining union. Okay? Kasi pagka nag-election pa lang, ang tawag contending union. Pagka kayo ay nanalo na, certified ka na. You are now the bargaining agent or bargaining representative. Habang nagbabargain kayo, bargaining union, nagkaroon na kayo ng contract, yung CBA, ang tawag na doon sa union ay contracting union. Napakaraming katawagan, kaya nagugulo ang sanlibutan sa labor code na ito. Dapat itong labor code ang pinakamadaling intindihin. Kasi ito ang batas para sa mga manggagawa. Eh kaso nga, yung mga ordinaryong manggagawa, hindi naiintindihan itong batas na ito. Paano naman tayo niyan? O, di ba? Okay. So a CBA should contain all the terms and conditions of employment, including mechanism for resolution of grievances, which if we have time, we will discuss that. Okay? So, the CBA must be published. Kasi ang nakipag-bargain yung mga opisyal. In fact, hindi lahat ng officers suma-attend ng bargaining. Di ba? So, kailan nyo ipapublish ito? Publication is by posting in at least 2 conspicuous places in the premises of the employer. Ano ba yung conspicuous places? These would be the places where people would normally congregate. Alam nyo kasi, itong Department Order 40-03, 2003 pa yan. Kaya wala pa sigurong Facebook noong mga panahong yan. Kaya hindi na ilagay na pwede nyong ilagay na lang sa wall ninyo o kaya i-PM nyo. Diba? O kaya ng group chat yun ilagay. Mas mabilis yun eh. Kaya lang, ito, luma yan eh. Kailan ito ipopost? 5 days before the scheduled ratification. If you do not post your CBA, that is a fatal defect because you violated the right of the members of the bargaining unit to information. They were not informed what is in the CBA. Diba? And the posting or publication of the CBA according to the Supreme Court is the responsibility of the employer. Okay? Now, during ratification, all the members of the bargaining unit must vote. In our example earlier, there were 100 employees in the bargaining unit. Lahat sila boboto. To ratify the contents of the CBA or the CBA itself, you need majority vote again, 51. Eh paano kung 50 lang ang bumoto? Ay problema natin yan. Hindi pwedeng i-rehistro yan. Ibabalik natin yan sa bargaining table so that those provisions objected by the employees will be renegotiated para maging katanggap-tanggap sa kanila. Now, if it is ratified by the employees in the bargaining unit, it should be registered to the Bureau of Labor Relations. Pero wag na kayong pupunta sa BLR. Pwede naman yan doon sa Labor Relations Division ng Regional Office. Delegated function yan. Okay. If the CBA is not registered, it is still valid and binding between the union and the employer. But you cannot invoke the operation of the contract par rule provided under Article 238 of your Labor Code. What is that? That if there is a valid CBA, valid meaning it is registered with the, remember, kahit naman hindi siya registered, valid siya. Okay? Between the employer and the contracting union. But it will not bind another union. Yung natalong union kanina, magpapail ng petition for certification election yan. Ha? Kaya irehistro ninyo para mapigilan yung pag-file ng petition for certification election. Kasi pag hindi nakarehistro yan, magpa-file ng petition for certification election at any time, lagot kayo. Diba? So kaya nga sabi ko sa mga estudyante, pag may bago kayong jowa, irehistro nyo. sa BLR para secured kayo within 5 years kasi may contract bar rule. Ano yan? The contract referring to the CBA will bar any petition for certification election for 5 years. The only exception is during the freedom period. The freedom period is the 60 days before the end of the 5 years. Take note, under Article 264 and 265, merong dalawang lifetime ang CBA. Buti pa yung pusa siya, mano. Ang CBA, dalawa lang. One, yung representation issue, that is the maximum 5 years. At pangalawa, yung 3-year period. Ano yung 3-year period? On the 3rd year, you can renegotiate only the economic benefits. Why the economic benefits alone? Kasi naman, after 3 years, ano bang nangyari? Nagmahalan ng lahat, di ba? Yung gasolina at diesel, magkano na ang presyo niyan? Now, is it mandatory? It's not. If the union does not want to renegotiate, so be it. Anong papasok dyan? Yung automatic renewal hanggang 5 years yan. So when is that freedom period? The freedom period is the 60 days before the end of the 5 years. Doon lang ang freedom period. Okay. In your screen, there's that example of the freedom period. So mag-expire siya June 9, 2025. Kailan ang freedom period? That would be 60 days before June 9, 2025. Bakit June 9? Ba marunong pa kayo, birthday ko yan. Okay. Now, what about the automatic renewal clause? When the CBA expires and there is no new CBA, syempre, nag-expire. Wala pa namang kaagad-agad na CBA yan. All the terms and conditions will be renewed until new CBA is concluded between the union and the employer. In some books, that is called evergreen clause. Why evergreen? Kasi hindi siya nagbabago winter, spring, summer, or fall. Hindi katulad ng mga sakura, di ba? Pagka spring lang yan, o pagdating ng winter, wala na yan. Yung evergreen, palaging green. So, for example, nag-expire yung CBA natin May 15, 2023. Pag sweldo natin sa May 31, hindi na natin makukuha yung mga benepisyo under the old CBA. Wala pa tayong bagong CBA. Wrong. Then that old CBA will continue to be enforced until a new one is concluded. It is different from automatic retroaction. The automatic retroaction clause provides or pertains to the economic provisions that any provision or economic benefit concluded by the union and the employer within 6 months from expiration shall retroact to the day after its expiration. So huwag kayo malilito. Between automatic renewal na madalas itanong, itong automatic retroaction hindi masyadong itinatanong. Example, you have that on your screen. The CBA expired June 9, 2018. Assuming it was the 3-year period. Okay? We renegotiated the economic provisions and we were able to secure a 20 pesos daily wage increase. We concluded it within 6 months. June 9 to November 9, 2018, yan po ay 6 months. 5 months pa nga lang yan. So when is the effectivity of the 20 pesos per day salary increase? That would be June 10, 2018, the day after expiration. Okay? Ngayon, what if nag-agree tayo after 6 months? Di syempre, by agreement of the parties. Natural, ang employer ayaw niya mag-retroact, malaking babayaran niya. Ang union gusto niya mag-retroact, malaki kikitain nila. So they cannot agree. Anong gagawin natin? Arbitration tayo. When is the effectivity of an arbitral award? The arbitral award will take effect on the date set by the voluntary arbitrator. Okay? If you do not agree with the decision of the voluntary arbitrator, appeal it to the Court of Appeals following Article 276. Okay? Why? This interpretation of the CBA is a form of grievance under Article 273. Take note, there are two possible sources of grievances in the workplace. Interpretation and implementation of the CBA provisions. Katulad nga, nung automatic retroactivity. Interpretation or enforcement of company personnel policy. Ito yung mga policies na nakalagay dun sa company manual or mga policy ng employer na hindi kayo nag-agree. This will be sources of grievances. So what do we do with them? We establish a grievance machinery in the CBA. Sometimes though, they forgot or they can forget the inclusion of a grievance machinery. So paano natin mariresolve ang mga grievances? The employer and the union must create a grievance committee pursuant to the implementing rules within 10 calendar days from the execution of the CBA. All grievances must be submitted to the grievance machinery. The grievance machinery or the grievance committee, as the case may be, shall act on it within 7 calendar days. If they remain unresolved, they have to be automatically forwarded to the voluntary arbitrators pag marami, panel of voluntary arbitrators. Sino ang voluntary arbitrator? Hindi yan empleyado ng Department of Labor. Yan po ay accredited lamang ng National Conciliation Mediation Board. Or even if not accredited by the NCMB, he is selected by the parties to act as their voluntary arbitrator. Whereas, meron din tayong mga compulsory arbitrators. These are mandated by law to resolve all issues in labor and their jurisdiction is provided for by law. Sino yan? The Regional Director, the Secretary of Labor, the BLR, the Labor Arbiter, the NLRC. These are compulsory arbitrators. Whereas ang voluntary arbitrator, these are the ones chosen by the parties or accredited by the NCMB. Take note, wala ang NCMB sa original na provision ng Labor Code because it was only created during the time of Cory Aquino. Executive Order number 251 created this, amending an old executive order in the same year, 1987. So yung trabaho dati ng NCMB, trabaho ng NCMB ngayon, trabaho dati yan ng Bureau of Labor Relations. So inilipat sa NCMB, when NCMB was created, nakagaan ng konti ang buhay ng BLR. No? Okay? Now, all CBA violations are called grievances. Exception yung gross violation of the CBA. Ano ang gross violation of the CBA? It shall mean flagrant and or malicious refusal to comply with the economic provisions of the CBA. They are no longer considered under the jurisdiction of the voluntary arbitrators. Why? They are considered unfair labor practice. So who has jurisdiction over unfair labor practice? You go to Article 224. That's the labor arbiter. Okay? So take note, simple violation of economic provisions, a voluntary arbitrator. Gross violation of economic provisions, then you go to the labor arbiter. Aliwanag. The voluntary arbitrators also have jurisdiction over wage distortion issues in organized establishments. Under Article 124 of your Labor Code. The parties may agree, however, to submit other labor issues like unfair labor practice or illegal dismissal to the voluntary arbitrator's jurisdiction. But according to the Supreme Court, there is a need for an express stipulation in the CBA that these parties, the union and the employer, agree to submit to the jurisdiction of the voluntary arbitrator the issues like unfair labor practice and illegal dismissal. In the absence of such express stipulation, hindi natin pwedeng ibigay kay voluntary arbitrator ang mga issues na ito because these are under the jurisdiction of the labor arbiter. Okay? So, the voluntary arbitrators, upon receipt of the grievances which were unresolved after 7 calendar days, no? Under Article 276 must rule or issue a ruling or judgment or order within 20 calendar days. Of course, that can be extended by agreement by the parties. Now, The decision of the voluntary arbitrator is final and executory within 10 calendar days, sabi ng Article 276. The implementing rules prohibit us from filing a motion for reconsideration. So ano ang remedyo? You go to the Court of Appeals. Pero sabi ng Korte Suprema, mag-file muna kayo ng motion for reconsideration. Eh sabi po ng implementing rules, marunong pa kayo. Korte Suprema na nga nagsasabi. So that prohibition to file a motion for reconsideration from the decision of the voluntary arbitrator is now a thing of the past. Repealed na yan. Because of this decision of the Supreme Court in Guagua National College versus Court of Appeals. That if you receive a decision from the voluntary arbitrator, the 10-day period is the period in which you file a motion for reconsideration. After the motion is denied or whatever happens to your motion, that's the time you go to the Court of Appeals using Rule 43, and under Section 4, you have how many? 15 calendar days. Okay? Kasi ang sagwa, dati-rati kasi ginagawa dyan, within 10 calendar days, final and executory, may 15 days ka to file an appeal. So ginagawa natin dyan, substantive over procedural. But now, no more. The Supreme Court clarified it. You file a motion for reconsideration first before you file an appeal to the Court of Appeals using Rule 43. And you have 15 calendar days under Section 4 of that rule. Okay? Kasama yan dun sa last paragraph, last sentence ng second paragraph, voluntary arbitrators authorized by law. Kasama dyan ang mga voluntary arbitrators sa Labor Code. But please do not use Rule 65. You can only use Rule 65 if there is no plain, available, speedy, adequate remedy under the ordinary course of law. If you have an appeal, utilize your appeal. Do not use Rule 65. Kaya lang, siyempre, may appeal fee. Bakit? Hindi ka naman magiging ma-appeal kung wala kang bayad. Gagastos ka talaga. Okay? Maliwanag yan. So, hindi na nagkasundo talaga eh. Ito na, solusyon. Mag-strike ka. Ano ba ang strike? Hindi na may tanong ito, no? Kasi ayaw ng gobyerno natin na nag-i-strike. But it is provided for under the law. Ano ba yung strike? Temporary stoppage of work caused by the workers due to a labor dispute. Tandaan nyo, yan napakasimpleng definition. That's also the definition under Article 2190, adopted by the Supreme Court in many cases. One is Biggs versus Bungkakas. O yung mga taga-Bicol, alam nyo yung Biggs, di ba? Maliit lang naman na tindahan yan, pero Biggs. Fast food yan. Kung ayaw nyo mag-Jollibee o McDo, mag-Biggs kayo. What about lockout? The temporary refusal of the employer naman to furnish work because of a labor dispute. Bakit lockout? Kasi pinalabas muna yung mga empleyado at saka inilock. Kasi kung nasa loob sila, lock in. Ako, serious illegal detention naman yan. Bawal yan. So, labor dispute. Okay? What about picketing? Ito yung ginagawa ng iba sa inyo ngayon. Naantok na. So, nag-picketing na. Picketing or peaceful picketing is the right of the workers to peacefully march to and fro. May mga dala daw silang mga placards. Gusto pa ba ang placard ngayon? Parang mahirap naman dalhin yung billboard. Masyado mabigat. So, inilalabas nila mga hinaing nila. Is there a need to have a strike para mag-picketing? Hindi. Picketing is the exercise of your freedom of expression. Kaya lang, do it legally. So, it is governed by your Public Assembly Act. Batas Pambansa bilang 880. Liwanag. Now, what are the requirements of a valid strike? You must have a valid ground. Hindi basta-basta nag-i-strike ng biglaan. Otherwise, wildcat strike yan. O kaya yan ay quickie strike. Bawal yan. Okay? What are the valid grounds for a strike? Bargaining deadlock, unfair labor practice, and the worst form of unfair labor practice ay union busting. Okay? Now, union busting is the dismissal of union officers. But take note, in that case of Adamson University that we have studied earlier, when the employer dismisses a union officer, it does not mean unfair labor practice immediately, especially if there's a ground for the dismissal. Okay? Now, meron kayong grounds, you notify the NCMB. If your ground is bargaining deadlock, economic yan. Kapag bargaining deadlock, economic provisions yan. Hindi kayo nagkasundo. So, 30 days. Okay? 15 days in case of unfair labor practice. Now, In case of union busting, there's no need to notify the NCMB. Hindi BLR mga kapatid. Dati BLR pero ngayon under the new law, NCMB. New 1987 pa yan. Notify the NCMB. Pag union busting, there's no need. But, kukunin natin kaagad ang strike vote. Papaliwanag ko sa inyo mamaya ng konti. So, nag-notify ka. From the time you notify the NCMB, let us take a look first doon sa bargaining deadlock. Economic grounds. Yung from the time you notified NCMB, within 30 days, di ka pwede mag-strike. Pag unfair labor practice, yan po ay 15 days. So, walang cooling off period pag union busting. Okay? So, yan ay cooling off period. Hindi pwede mag-strike within that period. Ano ang ginagawa during the cooling off period? Ang purpose po nito ay pag-usapin kayo. Maghanap ng solusyon. Para sa mga magjojowa, di ba? Kapag ka masyado nang mainit ang mga ulo, hindi na magkasundo, tuwing magkikita, nag-aaway. Mainit ang ulo, anong gagawin? Mag-cool off. So pag nag-cool off, anong ginagawa? Naghahanap ng solusyon. At huwag maghahanap ng bagong karelasyon. Magkakaproblema lalo ang sitwasyon. Okay? Kasi yung iba nag-cool off pa yung pala maghahanap ng bagong karelasyon. Bawal yun. So during the cooling off period, the NCMB will facilitate the conduct of preventive mediation. Why preventive? To prevent the strike or lockout from happening. Okay? So during the cooling off period, nasolusyonan, hindi tapos na yung strike. Remember, the requirements for a valid strike are also the requirements for a valid lockout. May konting variation lang. Okay? So nasolusyonan, hindi tapos. Hindi nasolusyonan. Nako, ang gagawin natin, you notify the NCMB that you will conduct a strike vote within 24 hours. Kailan kayo magno-notify? It does not matter when. Walang sinabi kasi ang batas. Ang gagawin nyo lang, within reasonable time, hindi na talaga nagkasundo, mahirap na maipagpilitan kung ayaw na talaga. So you notify the NCMB, hoy NCMB, kukunin namin ang strike vote tomorrow. Sabi ni NCMB, o di kunin nyo. If you fail to notify the NCMB, that would render your strike illegal. Kahit na nag-comply kami sa ibang requirement, yes, all the requirements must be complied with strictly. Otherwise, that would be an illegal strike. So, din-notify natin ang NCMB, you now get the strike vote. You gather not only the majority, but all the members of the union. Yung hindi miyembro ng union, huwag nyo isali. Okay? So, notify the NCMB na tapos na, kunin na natin ang strike vote. Secret balloting ito, no? Ayan. And then, ano ang purpose ng notification na ito? Para ang NCMB naman makapagpadala, mag-supervise ng eleksyon. Kasi alam nyo, kahiyaan minsan ito. Ang nagbabanta kasi ng strike yung mga officers. Remember, particularly if it is an economic strike or economic deadlock, no work, no pay tayo dyan. Sino ba naman ang gustong walang sweldo? Diba? So, ni-notify ang NCMB, nag-conduct ng strike vote, report the strike vote to the NCMB. Okay? Now, ayan. Nakuha na yung strike vote, i-report sa NCMB. From the time you reported the result of the strike vote to the NCMB, bawal mag-strike. We call it the 7 days strike ban. What is the purpose of the strike ban? The purpose is to give time to the NCMB to determine whether or not the decision to conduct the strike has the vote of the majority. Parang i-verify niya. Tama ba itong isinubmit na report? Majority gusto mag-strike. Why? Kasi alam niyo, as much as possible, although it is allowed, our laws discourage the conduct of this kind of concerted activities. Why? Ang epekto kasi nito sa ekonomiya natin. Remember in the 1990s, nagkaroon ng malaking strike dun sa Chrysler Motors na later on naging Pamcor. Natakot yung mga Japanese. Yan yung gumagawa ng Mitsubishi. Natakot yung mga Japanese kasi mahigit sa buwan yung strike. So, walang production. Ano ginawa ng mga Japanese? Inilipat sa Thailand yung kanilang production. O sino nawalan? Eh di ekonomiya natin, di ba? Lumiit ang production ng Mitsubishi dito, nilipat pa doon sa Santa Rosa, Laguna. Ibinenta yung pagkalaki-laki nilang lupain dyan sa Cainta. Okay? Because of that strike. That's why, although, as I said, it is allowed by our laws, we discourage. Okay? Now, in the case of National Federation of Sugar Workers versus Obehera, mandatory requirement dapat ito, but you can get the strike vote and report the same to the NCMB during the cooling off period. Yan din po ang ruling dito sa Coca-Cola Bottlers Philippines Post-Milk Workers Union. During the cooling off period, you can get the strike vote. Report it during the freedom period, pero mag-observe pa rin kayo ng 7-day strike ban. To give you a clearer picture, kasi paiba-iba ang mga lectures dito eh. Kung pakinggan ninyo, lahat na nagle-lecture, magkakaiba ang mga lectures namin dyan. Ito na lang ang paniwalaan nyo. Hindi ko sinasabing ako lang ang tama, kaya lang ito ang nakalagay sa jurisprudence. So, nagpadala ka ng notice of strike sa NCMB, June 1. Dahil meron tayong cooling off period, hindi ka pwede mag-strike from June 1 to July 1. That's 30 days, di ba? Oh. Kasi first day excluded, last day included. And then, kinuha natin yung strike vote, pero mali, no? Tingnan natin. Ayan. Bago nyo kunin yung strike vote, may nawawala eh. Ayan. Notify the NCMB on June 19. Teka muna, nag-notify tayo. Bigay tayo ng notice of strike June 1. Siguro naman sa loob ng 18 days. Kung magkakasundo na yan, di ba? O hindi talaga magkasundo, matigas talaga sa employer. O hindi, notify the NCMB. O tomorrow we'll get the strike vote. June 20, we got the strike vote. Alangan naman ma-report natin ng June 20 yan, unless nagmamadali kayo. We reported it June 21. From June 21 to June 28, yun yung strike ban, hindi ba? O, dapat makapag-strike na tayo ng July 1 or July 2. The answer is no. Bakit? Patatapusin nyo pa rin yung July 1 at dadagdagan nyo pa ng 7 days. So kailan na yan? Dapat July, na tayo? July 8, Di July 9. July 8 dapat makapag-strike na kayo. And these requirements are mandatory. Why? If you do not comply with any of these requirements, that would render your strike illegal. And what are the consequences of an illegal strike? Of course, the union officers may be dismissed after due process kasi may just cause ka na. The members of the union who joined an illegal strike may not be dismissed at all unless they participated in the commission of illegal activities. What illegal activities may be committed? They are all enumerated under Article 279. Do not block the ingress and egress of the company. Akala kasi pag naka-strike, harangan mo yung gate, mali po yun. Kasi naka-strike lang yung union. Paano yung mga hindi nyo membro? O pwedeng pumasok yun. Kaya lang, inihekel naman sila, di ba? Now, hindi bawal mag-strike sa ospital. But maintain a skeletal force. Yan ang sabi ng Korte Suprema in that case of Capital Medical Center versus Trajano. Maintain a skeletal force. Kasi life and health ang nakataya dito. Now, in an industry indispensable to national interest, the Secretary of Labor may assume jurisdiction and decide it. That is assumption of jurisdiction. Bakit siya nag-assume? Kasi hindi kanyang power yan. Remember, the power to decide whether the strike is legal or not belongs to the labor arbiter under Article 224. Kaya lang si Secretary, kung gusto niyang mapabilis, he assumes jurisdiction. Nagiging assuming siya, hindi kanya yan eh. Kaya lang in-assume niya, may kapangyarihan siya. Resolve niya. Legal yung strike niyo. O ano ang mangyayari pag nagdesisyon ng Secretary of Labor? Ay di pumunta ka sa Court of Appeals via petition for certiorari under Rule 65 after the denial of your motion for reconsideration. Si Secretary nag-assume. Pero ayaw niyang desisyonan, isinertify niya sa NLRC. So certified cases sa NLRC, the Commission will conduct hearings, doon na kayo, follow the procedure of the NLRC. Okay? Now, that power can also be invoked by the President. Because if the Secretary can assume jurisdiction, more so than the President, yung bossing niya, pwede mag-assume ng jurisdiction niya. Now, if the strike is already ongoing or if the lockout is already ongoing, the assumption of jurisdiction will have the effect of a return to work order even in the absence of a separate return to work order. Automatic yan. Na pagka nag-assume ng jurisdiction, you return to work. In case of lockout, you reopen the gates and let the workers go back to their work. Otherwise, the strike or the lockout will become illegal for defying the assumption order. Okay? Take note of the consequences of an illegal strike. Now, even if you have complied with majority of the requirements and you forgot to comply with one, the strike will still be declared illegal. Ganon kahigpit ang batas natin pagdating sa legal o illegal strike. Tandaan nyo yan. Okay? Now, under Article 284, and this was asked in the 2015 bar exam, up to what extent can aliens participate in union activities? General rule, aliens are not allowed to participate in union activities. Exception under Article 284, if that alien has a valid working permit and in his country of origin, Filipinos are also granted the same right to unionize or the principle of reciprocity. Okay? Paliwanag tayo dyan.